Welcome to TVASIA Immigration Updates. Every week we come on Sunday at 8 p.m. Central Time. Along with me today is my business partner, Rebecca Chen. Today I'm going to work as a host, and Rebecca Chen is going to be the immigration lawyer today. Rebecca, now we got this executive order. In this executive order, though, administration has given that they are going to promote the H-1Bs, they're going to promote the EB-1s, they're going to promote the NIWs for the people who have in the artificial intelligence. Can you elaborate with regards to how, if a person is on F1 visa, H1 visa, they want to get the green card, how they can exploit their green card? If they're on F1 visa, how they can get the H1B visa, and when this is going to be active?
Well, there are various timelines that the executive order sets out. So actually the main point of the executive order wasn't immigration necessarily. It is focused on AI and critical and emerging technologies. But as part of that, there are several immigration related provisions. So the executive order, for example, requires the State Department within 90 days of the order to come up with ways to, as the executive order says, streamline processing of visa petitions and applications for non-citizens that will be working in these areas of AI and critical and emerging technology. So it's very broad and vague. It's not very specific right now. It's just the Biden administration is directing the State Department to come up with ways to streamline the visa process. For the State Department, because the State Department is primarily in charge of the consulates, some of the items that they have listed are more along the lines of visa appointments, like making visa appointments more available for people who are working in these particular areas. We're not really sure how that will work, if there will be certain visa appointments or slots set aside for applicants working in those areas. Some other things that they ordered for the State Department, I believe within 180 days, is to add some skills to the J1 list of exchange trainees. So exchange visitors in the J1 program have to fit into a certain set of skills or occupations, so they're directing them to add AI and some of the emerging critical technologies to that list to make it more available for people to come over on J1 if they're working in those areas. And then as far as the DHS secretary, which is the department that oversees USCIS, there's a 180-day timeline to review and initiate policy changes to clarify and modernize immigration pathways for experts in AI or other critical emerging technologies, including O-1, EB-1, EB-2, and startup founders. So again, it's very broad. There aren't any specifics yet, but the executive order directs basically DHS and USCIS by extension. Within 6 months or so of now, we should be seeing something. We're not really sure what that would be. One of the suggestions in the executive order is to, which would be very helpful, is to basically update the Schedule A list of occupations. Schedule A is a program that basically allows certain occupations that have been identified by the government to have a shortage in the U.S. They get to skip the entire perm labor certification process, can go directly to the I-140 stage of the process after they've gotten a prevailing wage determination from their company. Right now, that Schedule A program is limited primarily to physical therapists and nurses and a few other occupations, but it hasn't been updated in a very long time. Updating the Schedule A list of occupations to include experts in AI and these critical emerging technologies would be a good step in the direction of helping them skip a very long and burdensome part of the green card process.
And so, Rebecca, if I'm on the F1 visa, I'm assuming that next year I'm going to apply in the quota, though. Could I expect that I can be given extra preference if I'm working in artificial intelligence?
I don't know about that. The executive order doesn't specifically mention the H-1B lottery. the proposed regulations that came out about H-1B modernization, which came out like a couple weeks before this executive order, that does include some provisions about the lottery system, but I don't believe it made specific carve-outs for people in AI or emerging technologies.
What about the possibility that if I can get an O-1 visa, just in case if the H-1B is not given, I don't get through the regular H-1B lottery? Is there a high probability for me to get an O-1 visa if I'm an artificial intelligence?
Yeah, you definitely still have to meet the criteria for the O-1 requirements, but I would say the executive order does definitely make it so that if you are working in one of these emerging technology areas or AI, it seems like the administration is basically telling officers that, you know, people in these fields should be strongly considered for favorable for an O-1 classification. We've already seen some of this actually starting from last January 2022. The Biden administration already published some directives to direct kind of a similar executive order to direct the agencies. They didn't focus as much on AI in that January 2022 executive order. It was more broadly on STEM fields, and O-1 was one of the areas identified where basically the what came out of that executive order was USCIS published examples in its policy manual of ways that people in STEM fields could meet like the 3 out of the 10 criteria, kind of thinking outside the box, you know, ways that hadn't in the past, maybe types of evidence that hadn't been considered by officers. They published lists of examples saying that, you know, if someone is working in a STEM field, for example, the fact that they've gotten a scholarship award from an R1 research university, that may not have in the past been considered the equivalent of a nationally recognized award, but basically as a result of that executive order, the policy manual added that as an example of a way to qualify for that criteria. So my guess is that from some of the executive order directions in this most recent executive order, that we should be seeing some similar kind of policy manual updates from USCIS to basically strengthen the chance of people in those fields of being considered for an O-1.
Okay, anything else, Rebecca, before I can go to the question Q&A?
Actually, another kind of interesting point in the executive order was that it also mentioned ways to kind of, as part of the streamlining of the process for USCIS, to find ways for startup founders using the International Entrepreneur Rule. The International Entrepreneur Rule it's already on the books. It was published some years ago. It has not been used very much at all by anyone in the industry. And that's the reason is because the requirements for the International Entrepreneur Rule are very burdensome. It requires a lot of specific personal and even financial information of the investors who are not the applicants. You know, the investors could be, you know, outside firms, outside individuals who are not, you know, not the foreign nationals applying for this benefit. And it's asking for a lot of their personal and financial information to qualify for the International Entrepreneur Parole. And I think that's why it hasn't really been used very much at all. It's on the books, but the hope is that maybe as a result of this executive order, there will be some kind of more common sense, practical adjustments to the International Entrepreneur Rule to make it more feasible for people in startups for AI or these other critical emerging technology areas to actually make use of that rule to be able to come to the US and found businesses and innovate.
So let's say, for example, if I'm working for Microsoft on H-1B right now, so most probably I can open my own business and have my own self on H-1B. Did the new H-1B rules make it easier for me to start my own company?
Yes, potentially as a result of the executive order, but also as a result of the recent proposed regulations for H-1B modernization. That did specifically also mention allowing H-1B beneficiaries to be the owners of the businesses that are sponsoring their H-1B. There are some limitations on that, like they won't get the full 3-year H-1B initially. It looks like it'll be 18 months, and then they can extend in 3-year increments after that. But yeah, if that part of the proposed regulation goes through, that will also go a long way in helping people who have been in the U.S. on H-1B for a long time, who have a lot of experience, who want to start their own business and contribute to the U.S. economy. That would be a very helpful way for them to be able to do that if they are still a long way off from being able to file the I-485 and get an EAD.
Thank you, Rebecca. I'll go to Q&A right now. 7393. Phone number ending with 7393. Can we unmute yourself, please? 7393. Hi, go ahead, sir.
Yeah, hi. Thank you for taking my call. So my question is, so I'm currently on pending AOS parole status, and I'm planning to travel to India in a few days. And I also have a advanced parole extension application, which is currently pending. So my question is, like, if I travel outside the US when this application is pending, would there be any risk of the AP extension being denied? And also, if the AP extension is approved when I'm outside the US, like, is this new AP extension still valid, and can I use it in the future for travel?
When is your current advanced parole expiring?
So it is expiring by the end of December. I'm planning to return back before that.
Okay, you will, first of all, you will have no problem whatsoever at all for you to go to India and come back if you're coming back when the advanced parole is still valid. Here is a question though. If the advanced parole extension is pending, we are not seeing USCIS denying the application when it is an extension though. We do see that if it's an initial travel, where people are traveling first time and they're traveling when the advanced parole is pending, the initial advanced parole is pending. We have seen denials, but the people who have filed for extensions, they're not denying it and they're able to use it, having had no problem with them at all. Okay?
Okay. And one more question is, like, if the AP is approved when I'm outside the US, can I still return back using the old AP?
If it is approved, yeah, absolutely. But you're returning back before December, is that right?
Yes, yeah.
Yeah, absolutely not a problem, sir. Absolutely, you can, even if it's new one is approved, since your existing advanced parole is still there, since your existing advanced parole is still valid until December, and you're coming back before the existing advanced parole is valid, then you have no problem, none whatsoever at all. Okay? We'll go to the next person. The next person will be a phone number ending with 0087.
Good evening, Rahul and Rebecca. Thank you for taking my call.
Sure, go ahead.
Sir, can you hear me? Okay,
yes, awesome. We can go ahead.
Yeah. Last week I called you, sir, regarding the automatic revalidation with the mixed crews, and you already confirmed it. But we came to know something very interesting, Rahul Garu. So we definitely want your expert opinion on that. So the scenario is, sir, this is a scenario, sir. The cruise which is traveling to Mexico, it's not going to Mexico directly. It is taking a stop, 8-hour stop in the Disney's private island, which is part of Bahamas. No. And one of my friends was telling,
that's once you touch Bahama, the automatic revalidation, if you are in H-1B, does not work. It works only for Mexico. Hello?
Okay, got it, sir.
No, it doesn't work.
Okay.
Now, there is a different set of rules for F1 visas for Bahamas. There is a different set of rules for H1 and H4 and L1, L2 visas, though. I don't want to go into the F1 right now, but let me tell you one thing. Once you touch the Bahamas, okay, the automatic revalidation does not work for you. Okay?
So this island, just a clarity, sir, this island is like a privately owned island. So even then, it's going to impact us, right?
No, the island must belong to some country, okay? You know the Nityananda Swami, right? He says, I own my own country. No, Disney can't say that, okay? Only Nityananda can say that I own my own country, okay? So it must belong to some country. So you're telling that it belongs to Bahamas, so it's a country. So it's definitely not Mexico, so you're out, okay? Don't go there. We'll go to the next caller. The next caller will be 0087. Can you unmute yourself? 0087.
Oh, I think that's the one that we just answered.
Oh, that's the one we just answered? Okay, let me try to...
Yeah, can you hear me? Hello?
Yeah,
hello?
Go ahead.
Hello?
Yeah.
Hi. Thanks for receiving my call.
Give me 1 second.
So my question is,
8482, can you answer, please? Can you answer the rest of the person? Can you wait for just 2 minutes? Let's answer the first person. 8482.
Yeah. Yes, this is 8482. Thanks for receiving my call.
Go ahead.
So my company filed my perm on October 9, 2023, and I have my 6-year H1, including the recapture days, left for about 343 days. That is 11 months, 8 days.
Okay.
So my question is like, since my perm is filed on October 9, 2023, so and my 6-year recapture days left is 11 months, 8 days. So what is my situation? Like, am I eligible for the 1-year extension of, if the perm process crosses beyond 365 days, will I be eligible for 1-year extension based on my current situation?
Rebecca, you want to answer it?
Sure. Not right now, you're not. So your 6-year limit has to be more than 1 year from the date that your perm was filed in order for you to be eligible for the 1-year H-1B extension. So if, like you said, right now, including recapture, you're at 11 months, about 8 days. Right now, you don't qualify, but if at some point between now and, next October, if you travel for at least, it sounds like, a little over 3 weeks and basically extend that so that your 6-year limit is now more than 1 year past the October filing date of your perm, then you will be eligible for the 1-year extension. Even if your perm is, you can apply for that H-1B extension for 1 year, even before you get to the 1-year mark of the perm being pending.
So practically, Rebecca, he has to spend 3 weeks or 4 weeks to complete that.
Yeah, about 4
the
weeks.
recapture time. As people need to be aware that any time that you spend outside the country will not be counted toward the 6 years. So since you are 11 months and let's say 7 days, so you're short by about maybe 25 days or 25 days, you can go to India or you can go to Mexico also and spend some time in Mexico and come back. Because if you go to Mexico, you don't need a visa to come back if you're coming back within 30 days. Good, you were asking some question.
Yeah, but my question is like, my perm is already filed on October 9. October 9 is last month, and today is like November 5. And starting from today.
They're taking more than one.
Starting from today.
So what is the date that your 6-year limit elapses right now?
Okay, so my perm is filed on October 9, 2023, and starting from today, if I count from November 5, my 6-year recapture days is 343. That is 11 months, 8 days, starting from today.
Do you know the exact date?
Exact date, 11 months, 8 days. I guess it's November 5.
You're confused. It's not from November. You have to count from October, from the time you file the labor certification. So that's the reason we're asking, what day is your 6-year expiring? Okay.
I calculated it as 340.
I think.
Okay, I will come back. Yeah.
If come back that date is beyond October 9th, 2024, then you don't need to travel more, but you'll need to just go to a date calculator and calculate out that date. If it's past October 9th, then you're fine, but it needs to be at least 1 year beyond the perm processing date.
we'll go to the next caller. 2325, can you unmute yourself? 2325. 2325. We have a little bit lag from the live show, so you probably need to there's a question that's come from Ankit. In the meantime, while this gentleman is going to unmute. Rebecca, from what time does a 60-day count, though? From what time does a 60-day count?
Mm-hmm.
From the for the layoff people, those people who get laid off.
Yeah, it is a bit of a gray area. From what USCIS has published in their guidance, they say it starts from the last date of employment. They haven't clarified to say whether is that the last day that you show up to work? Is that the last day that you get your paycheck? If you get severance pay, is it the last day that you get severance pay? So they've just said it's the last date of employment. I would say in our office, on the conservative side, we tend to interpret it, if possible, from the last day that you report to work, even if you have severance pay. It's usually safest to assume that it's 60 days from the last day you showed up to work, even if you have severance for another 3 months or so. So if you can file something, a transfer or a change of status within those 60 days, it's best to do it then. But I will say in situations where that hasn't been possible, where we've had clients that, they didn't get the job offer until after that initial 60 days has elapsed. If they are still getting severance pay, we have filed just submitting the last severance paycheck. And, if it was filed within the 60 days of that and we didn't get any pushback from USCIS. So that's not to say we won't in the future. But right now, it's best if you can file it within 60 days of the last date of employment. But if that's not possible, we have been able to file within the last paycheck.
2325. Go ahead with the questions.
Yeah. Hi, Rahul. Can you hear me?
Yeah, go ahead.
Yeah. So I have more from employer A to B. My H1 got transferred and approved till January 2026. Whereas my H4, my wife's H4 is not transferred. She has an approved one till 2025. That was with the old employer. So do they have to apply again for her?
You don't have to apply again to her immediately, but her H4 is expiring in 2025. You told me. When is your H1B expiring? 2026.
Mine is
right?
with the new one, 2026. 2026, right. Yes.
So before 2025, her I-94 expires. You have to file an extension. Does she have an EAD or just an H4?
She has EAD till this month, and but it was initially So, but we don't want to apply for the EAD. We just want to.
Okay, that's fine. Got the point. So she's technically good until 2025. Before 2025, her I-94 expires. You need to file an extension. Do you need to do it right now? No, you can do it in 2025. You don't have to do it right now. Okay.
All right. Okay. Thank you.
We'll go to some questions that are coming out here. Before we go there, there's one caller, we'll take it. Anybody who wants to, please call us. We have some slots open, so please try to reach us on the phone. 9540, you have a question for us.
Yes.
I
was calling, can you hear me?
Yes, I can.
Hello? Yeah.
Yes,
so,
we can.
Rahul,
Yes,
I have one question. Yeah, my visa was expiring in Jan 2024, and my company filed for an extension. And my company is working on the hybrid model, and my home address was listed as another work location. And I forgot to update I moved to a new address and I forgot to update it. So how do I solve this problem? Because my existing lawyer was asking, you have to go back to out of country and come back. So I was wondering, how can I solve this issue?
Rebecca?
Do you mean that, so your extension application, did you say is being prepared right now, or it's already filed and it's pending with USCIS right now?
It's pending with the USCIS, and I missed
Okay.
10 days deadline. I updated that was on 12th day.
Sorry, I didn't catch what you meant about the 10-day deadline.
I heard from my existing lawyer, they were saying that from USCIS it's mandatory that you need to update the address within 10 days, but I missed those 10 days and updated my address on 12th day.
You mean your personal home address?
That's right, ma'am. Yes.
Okay, well, that's not quite as necessary for H-1B applications. It's more necessary for like an I-485 or I-765 where they're mailing you something. Anything for an H-1B, all the correspondence will go to your company or your attorney. But did you say that your work location changed and your newest work location was not included in the extension application that is pending right now?
That's right, ma'am. Because my home address was listed as a alternative work location.
What about your previous H-1B? Was the home address listed there at that time? Was that not listed at that time?
No, that time it was filed in 2020. So
the answer to my question is that the home address was not listed in the previous application. That's the reason why your lawyer is now insisting on leaving the country, because you've been violating the LCA regulations from the beginning itself, not recently at the time when you filed the extension. So in 2020, when they filed the H-1B, they filed with office location. And somewhere between 2020 to 2023, you're starting working from your home. And now they are filing an extension, which you didn't listed your home location, but you didn't list it in the previous application also. That's the reason they're telling you to leave the country and come back. Let me ask you also, what about the home location and the work location? What is the distance between both the things though?
Less than 20 miles.
Less than 20 miles, you should be fine. You should not have any problem, because if it's less than 20 miles though, it comes into the same MSA qualification. Even if it's not an MSA qualification though, it comes as, we call it as a within drivable distance from your location. So you should be fine. I don't see that you need to go outside the country. Rebecca, you disagree or you're okay with it?
Yeah, same. If your only other work location was, within 20 miles of the address listed on the LCA, then that isn't a violation of the LCA. The LCA covers the entire metropolitan area of the address listed on that LCA.
And I just want to recorrect it, Rahul. In the previous extension, my home address was listed, but I was living in one place. So I just moved to 10 miles away from, like before my first home address was 10 miles within the office. Now I'm more less than 20 miles to the office.
Okay.
Then
you're good. You're good. I don't see any problem with that. You're good. I don't see any problem with that. Okay. We'll go to the next caller. Give me 1 second. The next caller is going to be 5234. 5234.
Rahul sir. Yeah,
yes, go ahead.
I have a question. So I have like a EB-2 with a clarity area of 2015, and I have a master's in data science here in US. Yeah,
EB-2, 2015 what day?
August.
Okay, keep going. August 2015 is your priority date. Go ahead.
Yes. And I have a master's in data science through my employer. Like kind of I did a master's here, and I'm also working in a couple of AI projects current work. So how this new AI regulation, like I haven't gone much time to go through this thing. How should I prepare for this?
Rebecca, if this gentleman is working in AI, his priority date is 2015 August. How can he take advantage assuming that the executive order will be implemented soon?
We don't know quite yet because the executive order so far is only very broad. It's just Biden is telling the agencies to find ways to streamline the process for people in these fields. But we don't know specifically yet exactly what the State Department will do, what USCIS will do to carry out the executive order. It sounds like we will know within the next 6 months or so. But yeah, at this time, we don't know for sure. But all we know is that the executive order directs these agencies to find ways to streamline the process, to basically find ways to retain people in these fields in the U.S. Through
Could it become easier for him to file a EB-1A category, Rebecca, because he's working in artificial intelligence? He has a master's degree in data science from past, it looks like 2015. That means that he must have had the data science degree 8-9 years ago, at least. So could it be easier for him to file an EB-1A?
Yeah, definitely. And I would say you don't even really need to wait for the implementation of the executive order actions for that. You don't need to wait the 6 months. I would say if you have extensive experience in AI and an advanced degree, I would, recommend definitely having your CV reviewed for EB-1 eligibility right now. Even if the executive order is not yet implemented, the administration is going to be more lenient with the AI people because the president has already directed USCIS. Okay. We'll go to the next caller, 8892. Phone number ending 8892.
Hello?
Phone number ending 8892. Yes, go ahead, sir, with your question.
Yeah.
Yeah, go ahead.
Yeah. I got my F1 visa in 2023. Then in my passport copy, there is one college name. After coming here, I changed it to the other college because the college I have in my passport told like there are no seats here. You should wait for the next semester. So I'm in the second college now. Like I transferred from one college to the other college. So again, I'm thinking to change the college in the next sem. Like, is it a good idea, like changing these many colleges?
Not a good idea, but what college did you change to right now, which you're going right now?
I'm in Cleveland State University right now.
And what college you intend to change to?
Yeah. Western Illinois University.
Do you see any problem? They all look to be okay universities to me, Rebecca.
Yeah, as long as they are not universities that, are known for issuing day one CPT, those are usually the ones that will be on the government's radar and kind of red flagged. So this
Western Illinois University doesn't seem to be a problem for us at any point of time. They don't look to be. So yeah, we don't feel any problem in you moving. The first university said they don't have time to take you in, and then you went to another university, and now you want to go to Western Illinois. We don't see any problem. It's only the day one CPT universities we feel are the problematic universities. Hopefully, so this time 8892. You need to unmute yourself.
Oh, I think that's the one we just.
Oh, that's the one we just did. Okay.
So I think it's 4469.
Yeah, 4469. I'm connected. Yeah.
4469. Go ahead.
Okay. Yeah. Hi. Yeah. So I have a question. So I'm a GC holder, and I got a new job in another state. So we want to relocate, but my wife, she's on still H1. So the thing is, like, we wanted to move as soon as possible within like a week or two. So my wife's H1 employer agreed to do H1 amendment. So since we are moving in a week or two, is that okay? We'll move and apply for amendment. Will that be an issue?
Technically speaking, you have to apply for the amendment, then move though. So if you say that, no, I already moved to Texas, and now you file an amendment, that is not legal. So you could wait for, it takes only 1 week for them, or 10 days at the most to file a H-1B amendment though. Have them file it and then move.
Oh yeah, that's the question. So now all the manager, all the stuff they agreed. So that only they are doing the process. So as soon they file the application, we can move, right, for the new address.
Absolutely. You don't have to wait for the approval. As soon as it's been filed, you can. But did you file 485 for your wife based on the F2A, or you did not yet?
Yes. Yeah. No, she's on pending AOAS, but still we did not get EAD, AP or something.
Got it. Got the point.
So, but we still plan to, within once she gets, like, we plan to move it. Yeah. So once we apply, as soon we can move, right, with the new address, and we can start moving.
Absolutely right.
Just we have to file it.
You don't have to wait for the approval. You don't have to wait the approval. Only filing the application would be good enough for you. Filing for the application will be good enough for you to move. Okay, the next caller we admitted is 5497.
Hello.
Yes, go ahead, sir.
Hello. Yeah.
Yes, go ahead.
Actually, yeah, my LCA is around 100K, and I have other income run around 80K. Actually next year around April I need to go for extension. Will there be any problem in the extension?
Extension, we are not seeing any problem in extension though, but we are seeing some problem when FTNS is coming to visit though. Typically when your salary is $100,000 but you're making $180,000, we're seeing some problem there, not at the time of extension though. Is the 80K what we normally have a consultation with your company, a company's immigration lawyer though? Because normally when people, for example, Rebecca is there. Well, I'll say that her salary is, let's say, 10,000. Okay, she actually makes 20,000. I mean, 10,000 extra. So the way it works in our office is that it's based on certain work that she does. I mean, even me, I get more than the salary. Rebecca gets more than the salary. It has to be documented very clearly. Is it based on the performance? Is based on what? So it's not that every month though you're getting this 80K. Like every month you're making, like, let's say, for example, $6,500. It does not look good. But if it works like a bonus though, it's perfectly all right. If it doesn't work like a bonus, it's every month, it may create a problem, especially when a FTNS visits.
They're actually running it as other income.
Doesn't matter how they're running it as. Are they getting it every month? Or are they not getting it every month? On what criteria they're giving you the $80,000? They need to document it and keep it ready if there is an inspection.
Okay. So, but for H1 extension, there will not be any issue.
Extension will not be a problem. And at the time of extension, you can do one other thing. You can correct it though. In the H1B extension, you can say that you're going to be making $180,000. So in that way that you won't be violating anything, everything will be all right. But until the H1B extension has been filed, you may want to look into how documentation. And if they really want to pay every month as another income, then you might file an amendment plus extension. That may resolve the problem if you file it as an amendment plus extension, because if you file as an amendment plus extension, then what will happen is that you can start getting that extra salary from now onwards itself. 7918, you have a question. Go ahead with your question.
Hi, Mr. Reddy.
Phone number
thanks
ending
for taking my call.
Yeah, go ahead. Sure.
Yeah, my question is very quick. So I was on EB-3. Unfortunately, my GC got rejected. I am back in India for almost 8 months. I returned to US. So one of my friends said that if you are in India for 1 year, you can apply for EB-1. So is that I need to continuously stay in India for 1 year or for past 3 years, or should I I can go back to India for another 4 months and come back and apply for EB-1?
Rebecca, you want to answer about the EB-1C?
Yeah. So that category EB-1C is for multinational executives and managers. It requires that the 1 year that you spent in India was spent working for a company that has a U.S. affiliate or a U.S. parent or subsidiary, some kind of relationship with a U.S. company. You have to have worked for 1 full year in a managerial position with the company in India. And then if they are transferring you to the U.S. in order to hold a managerial role in their U.S. affiliate, then the company can file for you in the EB-1C category as a multinational manager. But it requires all those elements have to be there. So it's not just spending 1 year in India. It has to have been working in a managerial role for a company that is going to transfer you to their U.S. branch or U.S. affiliate.
Practically, Rebecca, if he worked 8 months, let's say Infosys, if he goes back and as a high-level manager in India, if he goes back and completes the 1 year, then he will still come under the 3 years limitation that you said. And he comes back, and can only Infosys file the EB-1C, or can Cognizant file the EB-1C? Because he worked 1 year as a manager.
Yeah, it would need to be the organization that he worked with for 1 year as a manager. It would be that organization's U.S. entity that would file the EB-1.
Okay, so yeah, I've been working. I was working as a manager back in the U.S. as well as in India for last 8 years. So the only thing is,
is
like,
it the same company that? Is it same company?
Yeah, it is same company.
Okay. Yeah. If it's the same company though, since you worked 8 months though, you will have to complete the 12 months though. Not enough. 8 months is not enough according to Rebecca. And you must be at a high-level manager position there and high-level manager position here. Once you come back, they can still file EB-1C. But if you're eligible for it. Now, the major question that why did you get your EB-3 green card denied?
So my attorney, unfortunately, she didn't submit my medicals, and we lately realized even we sent out the documents, she didn't file it. I requested you, I reached out to you also in one of the situations, Mr. Reddy. You suggested wait, whatever the decision that USCIS gives, you need to go based on that. So unfortunately, they rejected it, and I had to go back to.
You could have filed a motion to reopen for that kind of. And then what happened with the motion?
We did file. It got rejected because it's not their problem.
Okay.
So
well,
I need to refile my.
Yeah, unfortunately, you should consider EB-1C if you think so, based on what you're discussing. Looks like you'll have to go back and work for 4 months and complete the 1 year, and then come back, and then at that point of time, you would be eligible for the. At that point of time, you'll be eligible for the EB-1C. Okay.
Sure. Thank you.
I'll take the caller phone number ending 8482.
Hey, hi. Hi. Can you hear me?
Yes, go ahead.
Yeah. So I called you back. So as I said, my perm is filed on October 9, 2023, and the remaining max 6-year timeout, including the recapture dates, is on exactly on October 10, 2024.
Okay, so then you don't have to spend any extra time outside the country. But just in case though, since they may say it's 1 year pending though, I would always spend 2 or 3 days extra in Mexico. Have a margarita in Mexico and come back. Okay?
Okay, because my situation is safe, right? I don't have to worry.
I still want you to spend 2 days in Mexico. Did you hear that?
Yeah, I got it. If I spend 2 days in Mexico, so my situation will be safe.
Absolutely safe. Because sometimes the calculation, I may go a little bit here and there, and that might mess up the calculation. So yeah, just that'll be much better for you to spend 2 days extra. I always promote Mexico for some reason, other reason. My wife's, that's the thing. Let's go to the next question. We have the slots for the phone call are free, guys. So if you can, please try to call the numbers. Questions from Mari Mahesh. Rebecca, does fake resume on AI technologies, how do the USCIS will eliminate the fake resumes on artificial intelligence, though? If they are preferring the artificial intelligence and people will fake the AI resumes, how do the USCIS remove those people and only give those people who are in artificial intelligence? That question's come from
that
YouTube.
remains to be seen. Like we said earlier, it's still a very broad executive order right now. We don't have many specifics. We should in the next few months, like 3 to 4 to 6 months is kind of the timelines for the different agencies. There should be more specifics when those come out. But yeah, we don't know yet how, for example, making visa slots available or priority for people in AI or emerging technology fields. How is the State Department or any government agency going to verify someone's work? For one thing, I very much doubt that they will go by the applicant's resume, because the resume is just going to be written by the applicant. I mean, even now for any visa application, we don't rely on just the applicant's resume. We include degree certificates, transcripts, employment verification letters, experience letters. So my guess is that it will also be along the same lines. It'll depend on experience letters, most likely from the company, verifying their duties in certain areas. I don't know if the government is going to have some kind of independent verification, way to research the company to verify that that company does work or engage in the fields that are being listed on the letter. We will still have to see. I doubt though that they'll just, rely solely on a resume.
1255, you have a question for us. Phone number ending 1255.
Can you hear me? Yeah,
Hello?
can you hear me?
Yes, we can. Go ahead.
Hello?
Yes, we can hear you.
Okay.
125.
Okay. The question is, I entered US on H4 visa, and since then I have gotten a change of status to F1, then a change of status to H1, non-profit. Now I haven't gotten a stamping done in all.
Ma'am,
sorry.
First, you got through the H-1B through the lottery system, is it right? Or
no,
it's always
first it was H4.
Go ahead.
First it was H4 in 2015. Then I got F1 in 2019. And then I got H1 cap exempt in 2020.
Got it. Keep going.
Now I am still on H1 cap exempt with employer B. And I want to go back to India. I haven't gotten visa stamping in all this while for last 7 years. How risky is it? And do I have the option to go to Mexico or Canada to get the stamping done?
Rebecca?
There shouldn't be any risk, as long as you have the approval notice and the employment verification letter from your employer to prove that you're working in your H-1B position, then it should be pretty straightforward. You can go to Mexico or Canada if you're able to get an appointment there. So right now, they're not requiring people to go to a consulate in their home country to get the visa stamp. So so if you would prefer to go to Canada or Mexico and can secure an appointment there, you can definitely do the application there. I don't really see any risk factors. You may want to have documentation of your maintenance of status from 2015, which would be your H4 approvals, your F1 I-20s, and then your most recent H-1B approval notices. But yeah, as long as you have all the documents, that should be fine.
Yeah, just because you moved from H4 to F1 to H1, we don't see that as you have done anything wrong. And since the time this administration has been since the time of Biden administration, the H4 approval, H1B approval stampings are relatively more better compared to the administration of Trump, though. So in fact, I would say that from the time of 2010 to right now, this is the best time that I would say that that stampings are going on more smoothly than what we normally experience historically, though. 7681, you have any question? Can you ask your question, please?
Yeah, hi, sir. Yeah, thanks for taking my call. So I have a question regarding, family-based 4 category. So our priority date is, August 2014. Okay. So do you think anytime soon or like 5-10 years, how long do you think it can become, the priority date can become?
What is the current date? I can't remember it, Rebecca. F4 category.
Let's see, the F4 category?
Yeah.
Yeah,
India.
F4
Priority date is 2014.
Yeah, F4, the final action date right now is in October 2005.
So he is in 2014. So typically, though, it doesn't move much faster. It normally moves, on an average, every year it moves about 10 months to about 14 months. So it averages out. So if it's 2005, yours is 2014, you may expect to not get your priority date current for the next 8 years at least. So between 8 years and 10 years is what I'm expecting your priority date to be current.
Okay. Yeah.
Okay.
Sure. Yeah. Thank you, sir. And one more question I have is I'm currently on H1 and my perm process has started, like prevailing wage is going on. So my max out is in June of 2025. So I mean, right now the timelines, looking at the timelines, do you think the I-140 approval will happen before that date?
Where is the process? Prevailing wage has been filed, or what's going on with that?
Filed in May of 2023.
Rebecca, you want to answer the question?
Yeah, I would say if your company, goes through everything, in a good amount of time, it's definitely possible to get the I-140 by June 2025. Prevailing wage processing times right now, we're seeing them pretty much 6 months pretty routinely. So I would say any day now, you should be getting the prevailing wage determination, and then the company, if they take care of recruitment pretty quickly, they could start recruitment already. So they may have already started recruitment. That can be done within 2 months if they take care of everything on time. And then once the application is filed, it's 10 to 11 months right now. 11 months right now.
12 months. 12 months. I would say 12 months, Rebecca, to be on the safer side.
Yeah, so it is possible with the current processing times. I will say that we're estimating that processing times for the perm application, the one that's at 11-12 months right now, that could potentially increase when DOL gets to processing the new versions of the form. They haven't gotten to reviewing the new form versions yet, which just came out over the summer. So there could be a slowdown there when they start reviewing those. But based on current processing times, it is definitely possible to get your I-140 by mid-2025.
9384, you have any question? Can you ask your question, please? 9384, can you unmute yourself, please?
Can you hear me?
938. Yeah, we can hear you now. Now, can you unmute yourself again? You muted yourself again. 9384.
Can you? Yeah.
We can hear you now.
Can you hear me?
We can hear you. 9384.
Can you hear me, sir? Okay.
Yes, we can.
Sir, my question is that my I-485 was filed in September of 2022, and I had got advance parole for 1 year. That expires in December this year. So my employer has filed for extension of advance parole. What I wanted to ask from you is that if I change my job in the middle while the advance parole extension is still pending, does the new employer need to immediately file I-485J?
We are not recommending people to file a 485J when they move the job immediately. It's not absolutely needed. You can always do it when the RFP comes in, or when there is an interview. But is it illegal to file I-485J if you move to a different company? No, it's not. Definitely not. Now, the question that you are focusing is that on the advance parole, do you need to file one more advance parole? Do you need to do anything about advance parole because you moved to a different company? Absolutely not. You don't need to do anything advance parole. Even though you moved, you changed a different company, you will get the advance parole. Advance parole will be given to you.
So in the case of my employer's attorney, all the advance parole cards or EAD cards or extensions, they first go to the attorney. So if I am not employed, is there a way I can notify USCIS that I am not employed by this employer, and they can send me?
You can do that. You can do that. Even if you do, though, but we see that sometimes they will still send it to the lawyer, old lawyer. The old lawyer will give it to you. Believe me, they will give it to you because it's a license issue for us. If we don't provide the document that belongs to the client, it's a license issue. So yeah, they will give it to you. But if you notify it, just in case if it goes to the old lawyer, he will still give it to you. Okay? We'll go to the next person. We'll go to the next person. This will be 4619. Phone number ending with 4619. 4619.
Hello?
Yes, ma'am. 4619, go ahead.
Hi, sir. Hello. Can you hear me?
Yes, we can.
Hello, sir and ma'am. I hope both of you are doing well. My situation is like 2 months back, I had my I-485 EB-2 interview, and it has been 2 months, and still I haven't received any RFP or any as such,
what kind of 485 is it? Is it family-based, employment-based?
It's employment-based, EB-2. And
is the practice date current?
Yes, it's current. It's the rest of the world.
Okay. So when did you file the 485 application, though?
It was October 1st, 2021.
Okay. Rebecca, you want to answer the question? So it's been 2 months. The prior date is current, and she filed in October 2021, which is almost like 2 years that she filed, more than 2 years that she filed the 485 application.
So at the interview 2 months ago, did the officer ask for anything additional? Did they make any indication?
No, she didn't ask for any. She didn't ask for any documents or anything. She didn't ask. She just said that if she would require, she would send an RFP. She had stated like that, and she had said like she would most probably give a decision within 2 weeks. She had said.
Okay, and yeah, it's still pending now. Yeah, I mean, hopefully they will take action on it soon, because it sounds like there's nothing preventing it from getting approved. The priority date is current. They must have finished the background check long ago, and if you submitted your medical exam, it sounds like there's nothing else that's needed. The main other option really in your situation is to potentially file a litigation suit, which our office has done. Our partner, Stephen Brown, has done in similar cases where the I-485 has been pending for a certain amount of time, and the priority date is current, and the government is just not taking action on it. So that may be something you can consider if it continues that there's just no response from USCIS, because what we don't want is for the dates to go backwards or anything like that, to the point that they're like, oh well, there's no visa available anymore, which is what happened to a lot of people a year ago. So unfortunately, from your side, that's really the only thing you can do to kind of compel the government to do anything. For the most part, they won't really respond to e-requests or follow-ups. You can potentially try to get your local congressperson, their liaison office can try to follow up. Some people have had success with that, but it usually takes a while. So I would say in the litigation suits that have been filed for delay cases in our office, typically Stephen sees turnaround within 60 days of filing.
We'll go to the next caller, 4803. Phone number ending 4803.
Hi, Rahul. Hi, Rahul. Good evening. I have a question. I have two questions for today. So just give a background about myself. I'm currently working as a postdoctoral researcher. I have a PhD in computer science.
You have to speak a little bit louder.
Okay.
Doctorate.
Can you hear me now?
Yeah, a little bit better. Go ahead.
Yeah. I'm sorry about that. Yeah. Good evening. I currently work as a postdoctoral researcher. I have a PhD in computer science, and my research is in the area of AI. So it's just to say that my work completely fits with the latest executive order. So my questions are: I'm currently on STEM OPT, which is set to expire next September. So my first question is: given that I'm currently on STEM OPT and set to expire in next September, and my student visa is expired right now. So is it advisable to go to Canada and get my F1 stamping done, given that my STEM OPT is about to expire within the next 10 months? Or should I hold
First
back?
of all, why do you need to get the stamping?
Just in case I have to travel outside for conferences, then I may have to miss out on attending conferences if I have to travel outside the country.
Rebecca, is it advisable when the STEM extension is expiring and he's in STEM extension? When you say postdoc, are you still in, what do you mean by postdoc exactly?
I mean, I'm a postdoctoral researcher.
In a university?
And yeah, I'm at the university.
Do you advise him to go to stamping, Rebecca, so that in future he doesn't have to travel out, when he wants to travel outside, he doesn't have to go for stamping?
It could be difficult. So at the consulate, when you're applying for an F1 visa stamp, the officers are trained to look at you as a student, and they're going to be looking at, your degree program. If you are in OPT, technically it's possible, but with your OPT expiring, a lot of times the consulates will be kind of reluctant to issue you a new multi-year F1 visa when you are not about to start a new degree program. If you're just in the US working on OPT and your plans are to continue working, like to switch to a work visa, a lot of times the consulates will be kind of reluctant to renew your F1 visa in that situation. I would say in your situation, do you have an employer who would be willing to file for a work visa for you? Because it sounds like you would be a pretty good candidate for an O-1 visa.
He could be also for H-1B cap exempt too, because he's working for the university.
Yeah, definitely.
So we would rather advise to get an O visa or H-1B and then go for stamping.
Yeah, go for stamping for that.
Oh, okay. Oh, that makes sense. Thank you so much. And my second question is regarding my green card process. Just to give a background, I have around 15 publications with more than 100 citations.
Let me tell you one thing, doctorate. Okay, let me tell you one thing. Right now, AI is on fire. So if you are working in AI, you are a postdoc though. Without even knowing about your publications, I can say you better need to evaluate yourself with the EB-1. The question would be more about timing of the EB-1. Would you do it right now, or would you do it after you get the H-1B? But go ahead. Yes, you said you have 15 publications, and that too in an AI field. Okay, keep going.
Yeah, so you kind of answered my first part of the question. Given the current situation, I think it's right to jump into the queue. But on the other hand, since I'm on F1, my H1 is not yet filed. Is it safe to initiate a green card process right now?
File the H1. What's preventing you?
Okay.
You don't come under the lottery system anyway. So what's preventing you to file a H1B?
No, nothing going on, actually. Most likely they will start by next spring. my H1 process. If everything goes through, my H1 should be in by next spring. So would you recommend me to wait until my H1 goes through, then initiate the process?
No, if you're sure that they're going to file the H1B for you, though, I'm going to file the I-140 for you right now, so because I don't want to delay going into the queue right now. Okay?
Okay. Yeah, that was my question. Thank you.
Oh, such a talented people. Next caller would be 9540. 9540.
Hey Rahul, I think you answered some part of the question. This is regarding the home location, Rahul.
What question?
My company that I was making, right now they filed an extension. My office location is listed as the primary work location.
Yeah, you're speaking within 20 miles. You're the guy within 20 miles from the work location.
It's around 20 to 30 around.
That should still come under, is it 20 or 30? Can you just Google it and find it out, please? Because
I just
from 10 to 20 to 20 to 30.
23.5.
Yeah, that's fine.
23.
For me, it still comes under a marathon distance. The marathon that I run is 26 miles. So yeah, it still is 23. That's good. Okay. Still nothing changes.
Okay. So the question is, like my lawyer was saying that you came under USCIS compliance issue. So I was trying to understand. I asked him a couple of questions, but he did not have appropriate answers. So does it really come under compliance issue?
Well, everybody comes under compliance issue, though. The main issue would be that did you violate any of the regulations, though? No, it's still commutable distance. That's the word we normally use. There are two things, though. One is called MSA, Metropolitan Statistical Area. Metropolitan Statistical Area sometimes covers even 40 miles. For example, Frisco to Dallas, parts of Frisco and to Dallas is almost like 30 miles. That is covered too. So that's called MSA. If you're covered within the MSA, you're fine. You don't have to look into the distance. Now, if you're not within the same MSA, then we look into are you in a commutable distance though? I think so. There's an article posted in our website. If you send an email to us, we will send it to you and send it to that lawyer about the article. But commutable distance is still covered on the LCA. You don't need a new LCA. You're not violating any new LCA. Let me go through some questions, Rebecca, here that there are some questions with regards to if the people who are on 485 application on EAD, if they get laid off, what are the options, Rebecca?
Yeah, so there are multiple options when you're using the EAD. So there technically isn't a grace period the way there is on the H-1B. Technically, for the I-485 to remain pending, you're supposed to have a continuous job offer. But that job offer, it can come from self-employment if you're on EAD. So, if you know that you are going to be laid off, if you can just have your own business set up and employ yourself, as long as it is a full-time position in a same or similar occupation to the one described in your I-140 petition, that qualifies as a job offer for purposes of continuing the I-485. If your spouse has an EAD also and they set up a business and hire you in a full-time position, same or similar occupation, that also works. Those are kind of the main options if you don't have something immediately available, like a new job offer. And if you want to, you can, do that self-employed alternative and be searching for another job while you are self-employed, and then move over to that new job so that there's no break in the continuity of the job offer.
I'm going to go through some questions very quickly. Yogita Shinde, birth certificate, non-availability certificate, they will accept it with additional documents, including affidavits and probably Aadhaar card, PAN card, ration card, election card. If you have any of those things, that's definitely good. When it comes to the marriage certificate, though, they are not accepting non-availability of the marriage certificate. What I would suggest you, Yogita, is that even though you may have been married 10 years ago, you can still go to India and register your marriage right now as if that it's been done 10 years ago. They do it. All you need is to take a wedding card and they will register it. That's the best thing. Otherwise, dealing with the USCIS is a big problem for you. Ramesh Patel is having, I'm planning to take my attorney at 485 interview. He's not in the same city. Can he join virtually? Yes, technically it's allowed for them to join virtually, Ramesh, but the problem is when we are virtually doing the interview, though, we don't have the video things, so we just only listen to what you guys are speaking. So when the lawyer is present there, he does observe the bodily feelings, the things that are going on, facial expressions of the USCIS official, facial expressions of the client, to evaluate all those things. You will miss a lot of those things. I tell people, those who are virtual interview for the 485, you might as well not, you don't even spend any money. You might have to save the money. That's my advice to the people, though. I know we have a lot of callers right now, but we are running out of time. Anything else, Rebecca, you want to speak before we leave?
No, not right now.
Thank you very much for tuning in, guys. So next week, the same time, 8 Eastern time, we'll be there next week on Sunday. Thank you for tuning in. Thank you.